This conference will now be recorded.
Hello, thank you so much for joining me today. My name is Angel Booth, and I'm the Senior Sales Executive here at PRC. And today I'm going to talk about the topics of trust and power of attorney. We offer a webinar training for this subject matter pretty much whenever our clients request it and whenever they like, but we know that sometimes it's really hard to adhere to a set specific schedule. So we do offer this on our YouTube channel, so that way you can take a peek and take a lesson when you have the time, where it's not so rushed. And we ask that if you come across any questions or concerns that come up during the webinar, you're absolutely welcome to reach out and email us. And you can email us at clientservices@prclosings.com. And with that, we're going to go ahead and get started. All right. First, we're going to talk about trust. Well, what is a trust? It's an estate planning tool that can replace or supplement wills, as well as help manage property during a borrower's life. And we always suggest that the borrower should seek legal counsel anytime they're creating a trust. The purpose of a trust is for the property owner, which is considered the trustor, the grantor, or the settlor, to transfer legal ownership to a person or institution, which we consider the trustee, to manage that property for the benefit of another person, and that would be the beneficiary. A trust also has three parties. We're going to have the settlor or the trustor, and that's the person who creates the trust. We have a trustee, and that's the person who's authorized to act on behalf of the trust. And then we have beneficiaries. That could be either an immediate beneficiary or a contingent beneficiary. The immediate beneficiary would be a person who is actively a trustee or settlor of the trust right now. A contingent beneficiary comes into place if an immediate beneficiary is no longer to act on behalf of the trust or if they pass away. How trusts affect reverse mortgage transactions? Well, the trust must meet state, lender, HUD, and title guidelines, and the trustee and borrower must sign loan documents. And what that means is that the trust acts as its own capacity. So if you have a borrower who's going to be vested in the trust, they're going to have to sign as trustee, and they're also going to have to sign as a borrower. So there are two separate entities. However, the trust is for the benefit of that borrower. Title and settlement needs for trust review. And basically what these items are things that we are looking for anytime a trust is submitted for review. That would be providing an executed copy of the trust and any and all amendments. We really do need that information because many times these trusts are created years in advance and many changes can happen from the trustees possibly passing away, getting married, not wanting to be the trustee anymore. All sorts of things can happen. So when an amendment is done, there's no way we would know that until we have sufficient documents and copies of those amendments. And so it's really important to have all of that information provided up front. We need to confirm if the trust is for our borrower's benefit. And what that means is basically the borrower should be an immediate or contingent beneficiary. But for the sake of lending, more often than not, it's pretty standard that the immediate beneficiary should be the borrower. The trust certifications are allowed in certain states. However, our settlement teams will make sure that they do relay that information to you as it applies in each state. And basically, also, we need to know if there's any deceased parties. So if you take an application, you know you're dealing with a trust, you know you've got a deceased spouse, or maybe one of the trustees is deceased and they didn't get a chance to amend that trust yet, just let us know upon submitting that application. Or even sometimes if you know it might be a little bit of a funky deal, have us do a pre-flight. We do offer that at PRC where you can provide us with full trust reviews or full power of attorney. We will review it up front before you open title. That way, if you think there might be an issue where your loan might not be able to close, we can address it up front, and we might be able to help point you in the right direction to get the borrowers the help that they need so they can get the loan closed, because it might take several weeks or several months, and you don't want to have to do another appraisal and have to update your GFE and all of those things. You could be kind of working on that on the back end and have a future deal to come, but you could still be working on it without taking the precious time of the processing time frame. Last but not least, you want to make sure that the borrower is competent. That is very important that we know that up front, because that's going to change the trustees if your borrower is incompetent. And just as a note, title will review for title insurance purposes only, and the lender will review for lender and HUD guidelines. Trust checklist. So these are the things that we're looking for when we are reviewing the trust. All borrowers must be the immediate beneficiaries and vice versa, which means the beneficiaries should also be the borrowers. We want to make sure that the correct trust is received. We want to make sure that the trustees have been verified and that the trust has the power to borrow. We want to make sure that the trust is signed and notarized. However, a copy is sufficient. We don't need an original trust for any transaction. Revocable or HECM loans, that's a lender requirement for the trust to be revocable. So we might come across a situation where you do see an irrevocable trust. However, the lender typically requires that the trust be revocable. Only some lenders will accept an irrevocable trust. And just as a reminder again, the trust must meet state, lender, and HUD guidelines, and title will only review for title insurance purposes. Reasons for trust denial. So these are some of the common reasons that trust can be denied. I'm pretty sure there are several, but these are kind of the common ones. You might have an irrevocable trust, and as again, some lenders will not approve that. An incomplete copy of the trust was provided, and that's a no-no. We're going to need all of those documents provided up front. If there's a trust certification provided, maybe it's missing or has insufficient information. If the trustor does not have all of the information that title will need to provide a proper review, that trust will be denied, and likely they are going to ask for the full trust. You can have a deceased party, which could cause the trust to split into a AB trust. It's pretty common where, because a person has passed on, the trust gets split, and that sometimes will make a portion of the trust irrevocable. And upon review, of course, we will let you know if that's the case. And if that is the case, again, many lenders will not allow for that to happen. I actually don't know of any lenders that will approve an irrevocable trust. But hey, we learn something new every day. That could all change. Laws change daily. So. Quick note, borrowers in Texas, they are not permitted to close within a trust. So if you do take an application and you're in Texas, make sure you're ready to have that conversation with the borrower. Many of them are probably already aware because it's a state-specific issue. They should be aware of that. Maybe not so much if they don't know much about a reverse mortgage, but just to have a little bit of leverage on your competition out there. If you are taking an application in Texas, reach out to us if you're ever concerned and you want to be well-versed and prepped when you're having those conversations. Reach out to us and let us know. But again, you cannot close in a trust or be vested in a trust in Texas. Reasons for trust denial. Going to have no power to borrow. That's a common issue, or the trust is maybe not executed. Maybe the borrowers are not listed as immediate beneficiaries and vice versa. And maybe the time for the trust has come for it to be distributed. We cannot close in a trust if the trust needs to be distributed. That process needs to be complete, and the updated vesting needs to be reflected before we can move forward. We would not be able to have a trust that needs to be distributed and handle everything through the closing. The trust would need to be distributed up front. So again, you run into that issue, you're always welcome to call us, and our settlement teams will walk you through that process. With that whole pre-flight situation, if you kind of know that might be the case, have us do a pre-flight on it. We can let you know up front what you'll possibly need and hopefully point you in the right direction if the borrower does not already have or is not already working with an attorney for that. Signature when using a trust. So this is basically just an example of what the signature lines are going to look like when you are vested in a trust for the trustee portion. So as you can see, basically it'll just show the trustee's name, comma, trustee, and that's going to be required anytime you have a trustee signature. So for instance, if my name is Angel Booth and I am the trustee of someone's trust, even if trustee is not written after my name, the file has gone through underwriting, the file's been processed, everyone knows Angel Booth is a trustee. those documents, when they go to signing, need to come back, and that notary and that trustee need to make sure that they sign their name Angel Booth, trustee, every time. It's just a known thing because things happen. There are human beings who are preparing loan documents. Errors occur. It's just kind of a known thing. So just FYI on that. And the lender will also require individual signatures for the HECM borrower on security instruments. So although you'll have many documents that are signed just by the trustee, when you're dealing with the fact that there's a borrower, you're going to have an actual borrower signature on some of the additional documents and security instruments. And so if your borrower is incompetent, that would be signed by the power of attorney. How vesting will appear. So this is an example of a standard vesting when using a trust. It should include the trustee, the name of the trust, and the date of the trust. So for example, John Smith and Jill Smith are the trustees of the Smith Family Trust, dated July 29, 2011. So it has to specifically state the names of the trustees, the name of the trust, and the date of the trust. So if you ever have a vesting that does not reflect that, pretty certain that you're going to have a deed request from your settlement team, having that to be updated and amended so that way when the transaction closes for the next transaction, it will reflect properly. Trust vesting issues. So these are some of the things that are going to come up. They're not deal breakers, but they're just common issues that we're aware of and that we come across. Trustee's name reflected within the trust does not match the trustee's ID, and that's a common issue that can happen. Again, these trusts are created so far in advance, and by the time the borrowers are using them, maybe one of their children is a trustee and now their last name has changed due to marriage, or maybe they just decided to change their name and that was not updated within the trust. So there's a lot of different reasons for that. Maybe someone, whoever created the trust, left out a middle initial, but their ID has the middle initial. So again, lots of reasons for that. Maybe the trustee's name is not included in the current vesting. So in the prior slide where it was saying the trustee's name of the so-and-so trust dated, that date, the trustee's name must be included as the example shows below. So it would be incorrect to show Jill Smith Trust dated July 2nd, 2017. It would need to state Jill Smith, trustee of the Jill Smith Trust dated January 2nd, 2017. You might also have an issue with there being an irrevocable trust, or the trust was amended and restated, but it's not reflected in the current vesting. So these examples are things that can typically be fixed with the correctory deed, and the settlement teams would take care of that through the process. Here are some requirements for deeding out of the trust. We're going to need a copy of the full trust and any amendments, signed supplemental instructions by the borrower. We're going to need direction provided from the borrower, and that word borrower is highlighted because we understand that the loan officers and the processors sometimes are very involved with helping with these loans up front, and they have already had these conversations with the borrower, and if the borrower has made that decision that this is exactly what I want to do, we understand that. We just need documentation of that. So it's really important that if a borrower is asking or needing to come out of the trust because the deal just won't work because it's in the trust, we understand that those conversations have to be had. And if the borrower is okay with that and willing to do so, we just need to have that in writing. So that's just a note on that. A deed prepared by the trust attorney or settlement team to be signed by the trustee, and a trust certification or trustee's affidavit to be executed by the trustee along with the deed. Those are just some of the basic requirements. Deceased beneficiary. So as we mentioned earlier, if you have a deceased party, the trust may divide into a subtrust. One of the subtrusts may become irrevocable, and that might cause an issue. It might not, but again, as we review each specific transaction, we will definitely let you guys know how to move forward and the best way to handle that. If the deceased beneficiary is the last surviving trustor of the trust, you have to look at the section of the trust which describes what is to happen to the property. If that section of the trust calls for the property to be distributed to the contingent beneficiaries, as opposed to the contingent beneficiaries become the primary beneficiaries, the trust may need to be distributed. So These trusts can be very intricate, and the more information you have, the better to provide us with to make sure that we are able to help you guys and help the borrowers get the loan that they need. And sometimes we have a couple of hurdles, but it's not anything that we can't work through or, again, lead you in the right direction. Of course, we are not able to provide any type of estate planning, but that doesn't mean that we would not be able to share information and help the borrower in any way that we can to make sure they're getting, what's best for them. Deceased settler. Again, the trust may divide into subtrusts, and one or more of the subtrusts may be irrevocable. Deceased trustee if not the borrower. So if we're dealing with a trustee who is not our borrower, typically we'll need an original county certified death certificate, and then the settlement team will prepare an affidavit of death and then advise of any vesting changes. And just as a note, requirements for the original or county certified death certificate vary from state to state, so just always be sure to check with us to make sure we're letting you know what you need. Again, up front, copies are fine to submit to get your order processed and going, but even if you're going to be providing copies of documents that you need the original of, I would absolutely make sure you're 100% sure your borrower does in fact have an original. We've had countless closings where the loan officer is trusting the borrower's word, and then when it came time for signing, we received a color copy back, or the borrower refused to give the information to the notary if the loan officer didn't attend, and it just causes a nightmare later down the line for pretty much everyone involved. So it's really nice to, again, submit your copies up front, but make sure with your borrower that there are, in fact, originals, and if we have some of those more reluctant borrowers, we're absolutely willing to work with you and help them feel more comfortable. We've done things like provide a FedEx return envelope down with the recording package to the county recorder for the death certificate or power of attorney, the things that need to be recorded to make sure the borrower feels a little bit more comfortable that those original documents will be returned to them after recording. Moving on, we're going to talk about incompetent borrowers. So when you're dealing with an incompetent borrower, you're going to have some successor trustees. Obviously, if the borrower was a trustee and they become incompetent, well, they can't be trustee any longer. So that's going to be one of the things that will change within the trust. We might also have an attorney in fact or a power of attorney or a conservator roll into the picture as well when you're dealing with an incompetent borrower. Hopefully, more often than not, the borrowers have a power of attorney set up prior to becoming incompetent. But if those avenues were not addressed prior to that borrower being deemed incompetent, then we'll start rolling into conservator and guardianship issues. But again, nothing that's new to us, and we deal with it pretty much every day. It's part of the reverse world. So absolutely here to help you guys if you run into anything like that. And just as a note, the power of attorney is used for the capacity of an individual, not the capacity of a trust. Two separate entities. Trust distribution. So when is a trust distribution required? Well, after the death of the surviving immediate beneficiary, the trustee is responsible for managing assets involved within the trust estate of another individual according to a trust agreement. One of the most important functions of the trustee is distributing the trust assets according to the wishes of the creator of the trust, which is the trustor or beneficiary, as set forth within the trust agreement. All right, so can title distribute a trust? No, we cannot. We've been asked on several occasions, which is okay because at least we know that our clients trust us to do so, but we're absolutely not able to do so. That process is something that is very intricate and involved, and that should be definitely handled by the trustee along with guidance from their trust attorney or legal counsel. All right, title requirements for trust distribution. First, we must have title review the trust and death certificate to determine if distribution is required. PRC will need a deed prepared by legal counsel and executed by the trustees into our borrower's name. If applicable, PRC will need an affidavit prepared by legal counsel and executed by the trustee, and that is state-specific. And we'll also need a copy of the recorded deed to update the title commitment. The reason why we ask for that is every state, every county is different, and how they record in the backlog varies so much. If you submit something to us and we do not find it of record, we have to wait to be able to pull that document of public record. However, if you have a copy of the deed with the actual recording information directly from that county, we can actually update our title manually, so that way we don't have to wait on the county to update their records. All right, now we're going to go into power of attorney. A power of attorney is a legal document appointing another person to manage the borrower's or principal's financial affairs. And when can a power of attorney be used? Well, we run into this when we have a mentally incompetent principal, a physically incapacitated principal, a competent principal, but they prefer not to sign. And just as a note, the POA is used for the individual capacity only. Powers of attorneys. So financial power of attorney is always going to be required. We cannot utilize a medical power of attorney. And also the original power of attorney is required at closing and must record with the mortgages or deeds of trust if the power of attorney is not already recorded. Types of power of attorney. Well, we've got our standard, which is effective upon signing. It doesn't have the durable verbiage, and lenders may reject a standard power of attorney if the borrower is unable to sign the loan application. And then we have the durable power of attorney, which continues to be effective even after a borrower becomes incompetent. We have a springing power of attorney, which only becomes effective after the borrower becomes incompetent. POA approval. These are just some of the basic things that we have to approve a power of attorney. We've got to make sure that the power of attorney lists the borrower as the principal. The power of attorney should have the power to borrow, mortgage, encumber, or hypothecate. It should list the agent or attorney in fact, should have the power to deal with real property, and it should be signed and notarized by the principal. And if that doesn't happen, you guys will know once we do the review. We'll definitely let you know if there's an issue with that. Here's a quick sample of a power of attorney. This is just a real general power of attorney, and it's a California example. So it'll just show like your principal's name and your principal's address and the agent's name and address. And then at the bottom there, you'll note that it has all of the different powers that be, if you will. And many times it should have all of the powers listed above, but if it doesn't, once we review it, we'll let you know. We'll get back to you and let you know if there's an issue. But I would say 9 times out of 10, we really don't run into too many issues with our power of attorneys. I would say the only issue we might have is the fact that maybe it wasn't, maybe it had the wrong acknowledgement for the document, something like that. Competent borrower. So durable or standard power of attorneys are acceptable, but must be reviewed to ensure that it meets guidelines. Principal's affidavit to be signed and notarized by the borrower. A competent borrower must be counseled and actually sign the loan application. So you have a borrower, they want to use a power of attorney, they're totally competent, and they want to use their power of attorney, they've got to make sure that they sign the loan application. If they can't sign the loan application, your lender is likely going to have an issue with that, and they will likely guide you from there on what you need to move forward on their end. And the power attorneys must sign the affidavit of attorney in fact. And just as a note, PRC will provide the affidavits on all of our power of attorney transactions through the processing. When you're dealing with an incompetent borrower, you're going to either have a durable or springing power of attorney. And either could be acceptable. It just depends on what is within each document prior to approval. The POA will reflect the need of 1 to 2 letters from a medical physician to determine the borrower's current mental capacity. In some cases, the attorney in fact will need to sign a court order to determine if the borrower is incompetent. And the power of attorney must sign the affidavit of attorney in fact, and again, PRC will provide that. Just a quick note on the doctor's letters. PRC only requires 1 doctor's letter unless the power of attorney states something different. And then the need for the power of attorney to get a court order, that comes into play sometimes if maybe we're having an issue getting sufficient doctor's letters. I know sometimes doctors don't really like to get too involved with financing or anything like that, but they're the only person that we can turn to get sufficient information when it comes to the power of attorney if we're talking about incompetency, and then it's their I can't say their duty to do so. I would say they should be responsible, and if someone's requesting that information with the proper authorization, they should provide it, but that doesn't always happen. So we have seen some instances where the power of attorney actually has to go to court to get a court order, and it's not necessarily the conservator portion. It still ties back to the power of attorney, but it's just to protect the borrower, to make sure that that there's not any type of elderly abuse or fraud or anything going on. And then here's just a couple samples of the affidavits that we use. We've got the affidavit of lack of knowledge of termination of power. Yes, that is a real document. I am not sure why they changed the document to say that. And then we've got an affidavit of principal, and this is to be signed by the actual borrower, the principal agent. Doctor's letter checklist. So the doctor's letter should always be written or typed on doctor's letterhead. They should include the date that it was prepared and include the doctor's signature. It should include verbiage that the borrower is no longer to handle their financial affairs. And depending on the title or lender requirement, the doctor's letter may need to state the specific date that the borrower became incompetent. And that's really important when we're dealing with documents that are signed in a record. If we're dealing with a power of attorney that got signed in 2010, but then they were incompetent in 2005, that's a problem, because we've got an overlapping gap of someone saying this borrower is not competent, yet they're still signing legal documents. So just a note on that. All right, we'll move on. What a POA can't do. So a POA can't be used for self-serving purposes, including removing an incompetent borrower from vesting. It cannot be used to sign on behalf of a trustee unless both the power of attorney document and the trust specifically allow for it. And all POAs must have the following. They should all have the power to deal with real property. They should all be properly signed, notarized, and witnessed if applicable. And the principal must appoint the attorney in fact within the document. Few reasons for POA denial would be a lack of power to borrow, maybe some invalid signatures, improper notary acknowledgement, lack or insufficient number of witnesses in certain states, or lack of durability language. Few more are you've got a springing power of attorney, yet your borrower is competent. And as we talked about earlier, the springing power of attorney only comes into effect when the borrower is incompetent. You've got maybe an insufficient doctor's letter. The original power of attorney is missing, which is required for recording. The principal was incompetent at the time the POA was executed, and that's one of the top reasons that we've seen before, or maybe the power of attorney doesn't conform to state guidelines. Signature when using a power of attorney. So as the example shows below, the signature line just says Jill Smith, but when that person signs that signature as being a power of attorney, it should always state Jill Smith by Jack Smith as attorney in fact, as Jack Smith is the power of attorney signing for Jill. Again, human nature, human error, documents sometimes are not prepared with the full verbiage typed out, but we do train our notaries and we do send that information over with our signing request to the notary, exactly what the signature line should look like. Even if the loan documents were not prepared that way, we really do try our best to make sure that the docs come back from closing signed properly. All right, now we're almost finished here. We're going to be talking about utilizing a trust and a power of attorney in a single transaction. When using a trust and a power of attorney in the same transaction, you'll need to follow the guidelines as previously discussed with this presentation. Remember that these entities are separate and should be viewed as such. It is common to have a trust and power of attorney used on the same transaction. However, there are circumstances in which a trust can be denied, yet the POA is approved, or vice versa. All right, so when we're dealing with a competent borrower, if the borrower is the trustee of the trust, the borrower must sign all documents as trustee unless a new trustee has been appointed. And the borrower must sign the principal's affidavit. The original power of attorney will be required to record unless it's a record already. And then the power of attorney must sign the affidavit of attorney in fact. Now, when we have an incompetent borrower, there's going to be an affidavit of change of trustee that'll need to be signed. And that, again, is if the borrower was the trustee. The successor trustee will then sign all of the documents as trustee, and requires a doctor's letter confirming incompetency of the borrower. We'll have to make sure we have to confirm that the borrower is in fact incompetent before we can deem that true and correct in the file. The attorney in fact will sign all individual signatures for the borrower, and again, they are signing for the individual capacity. The power of attorney must sign the affidavit of attorney in fact, and again, the original power of attorney would be required to record. And just a note, the attorney in fact will not always be the same person as the successor trustee. Vesting. So our trustee must sign in the capacity of the trust, and the attorney in fact, or the principal, must sign in the capacity of the individual. The trustee and attorney in fact may be different people depending on the trust and the POA documents. Signature lines when dealing with a competent borrower. So if our vesting is showing Jill Smith, trustees of the Jill Smith Trust, dated July 29th, 2011, your signature lines will look something like this. So for your power of attorney portion, which is the top signature, it's going to read Jill Smith by Jack Smith as attorney in fact. And then your second signature line will be the capacity of the trustee. And if Jill is competent, she would be signing on her own as trustee, with the power of attorney signing up above as attorney in fact. Now, when we're dealing with an incompetent borrower, the signature line is going to change just slightly. Same vesting, but the signature lines will then be Jill Smith by Jack Smith as attorney in fact, which is signing as power of attorney. And then the second signature is the capacity of the trustee, and that would then be Jack Smith because he is now the successor trustee. Some lenders kind of vary on what they choose to show. Some lenders will require that it actually say successor trustee. Many of them do not, but just a disclaimer on that. All right. All right, disbursement of proceeds. So we kind of added this slide in here just to talk about that a little bit, just because it does affect and alter how we disperse our files when we're dealing with a power of attorney. Dispersing in a trust. So if your borrower requests a check for their proceeds, the check must be payable to the name of the trust. We'll be unable to issue a check to an individual capacity if vested in a trust. If your borrower requests a wire transfer for their proceeds, a checking account in the name of the trust will be necessary. If an account in the name of the trust is not available, we will be unable to send a wire. Dispersing with a power of attorney. Borrower's proceeds will be issued in the form of a check and will only be made payable to the borrower. Wire instructions for the borrower's proceeds can't be accepted from the attorney in fact. In the case of a competent borrower, we can accept wire instructions from the borrower to the borrower's account. However, the instructions must be completed by the borrower and not the attorney in fact. So this is really important because we have to watch out for fraud, especially wire fraud, and our legal, I should say, have come to the conclusion that if there is a power of attorney, they should have the necessary access that they need to gain access to the borrower's account, whether that be in the form of a check or whether the borrower fills out the wire instructions and we wire per the borrower's request. But we can't have the power of attorney provide, checking or banking information to their account and send it or make the check payable to the power of attorney. Have to be made payable to the borrower. And just to touch on wire fraud again, in regards to closings, we will only accept wire instructions provided to our office by the notary at closing. After the closings, we will not accept any form of revised wire instructions in the form of an email, fax, or by telephone. And the reason for that is we actually do get our wire instructions notarized by the notary at the closing. And that was it. So this disclaimer just lets you know that this information provided herein is up to date as of May 20th, 2019. Information may vary by underwriter and state. It is always best to check with your settlement officer as to current or specific requirements for any particular file. And that's it. So thank you so much for allowing the time for me to go over that webinar training with you. It doesn't go in as deep as another webinar we do offer. Actually, you get CRMP credit for, and that talks about trust, power of attorneys, conservatorships, guardianships, remainderment. It's really, really in depth. So I encourage you guys to contact us if you'd like more information. We do an offer that webinar quarterly. And you, like I said, you get your CRMP credit for that one. So reach out at any time. But if you want something that's just a little bit more specific to the trust and power of attorneys, which are pretty common on many of our transactions, again, please feel free to reach out to us anytime. Hope you guys enjoy the rest of your day, and I hope to be hearing from you soon. Thank you so much, and thank you for choosing PRC as your partner in reverse. We appreciate your time.
This conference will now be recorded.